mind begin to swing.
Greetings from Castle Goring, from Mickey, Aurora, and from me. Well, today we have a very exciting, to put it mildly, matter to cover, which I have been dealing with via inquiries, and I have made extensive notes, which I might refer to, on a very serious matter, because it would appear that there is the possibility that the ground is being laid for, shall we say, the possibility of a future complaint against certain participants in a particular lawsuit that would involve conspiracy, criminal conspiracy. Oh dear, how does that work? Well, before we get into that, I'm going to read out what Omar Diane says, or Diane, I don't know which way it's pronounced. Just want to say I had a good laugh when I saw the royals wearing grey suits at their appearances recently. And Shawnee or Shaney Mitchell, my pronunciation depends on which side of the Atlantic one is on, says, at Lady Colin Campbell, will you be wearing a grey suit on your show soon? It seems to be very much on trend this season, with all of the royals wearing it very well in the last week. Shawnee Mitchell, I'm sorry, I don't have a grey suit. Sorry, I have black suits. I have purple suits. I have brown suits, but I don't have a black suit. So I'm afraid you're going to have to get me in something else. But isn't it interesting that Harry and Meghan make their accusations against the men in grey suits? And what does the Princess of Wales, what does Prince William, what does the King do? They immediately show up in grey suits. Now, we all know that the royals sometimes deliver messages via attire. And is it coincidence? Well, Freud says there's no such thing as a coincidence. And I don't entirely agree with that. But I do certainly think in certain cases it's stretching incredulity to actually say that they're not giving a message. And the message they are giving, in case people have missed it, which I would hope nobody on this channel would have done, is that they are supporting the men in grey suits, because the men in grey suits are supporting them and implementing their desires. It's as simple as that. You know, Harry came up with the fiction and bleated it across the world that the late Queen was a victim of those people surrounding her, including Sir Edward Young. And of course, he implied, but he didn't state it, Garter King, who announced that Harry was not able to be half in, half out. All of this was done with the consent, approval, and knowledge of the Queen. And in the last week or two, after Harry came here, and Harry then announced to The Guardian, an anti-monarchist newspaper, that he doesn't regret anything he said about any of the royals. He was simply clearing up misconceptions, and effectively that he was now going to be half in, half out, because he was kindly offering to pick up the slack for William, and that he would be coming back 4 or 5 times a year, and he, because the thing that counted most was his father. Oh gosh, shall we take up the violins and play? And blah, blah, blah. And then Meghan announces in the American press through Us Weekly and Page 6. There was a terribly emotional meeting, and H and his father collapsed in tears with each other. And what did the men in grey suits do? They promptly cleared up the fact that it was, as I had said, Harry had a brief meeting with his father, was treated as if he were a minor functionary, and there would be no half in, half out. They are giving a message, they being the King, the Prince and Princess of Wales, that the men in grey suits are supporting them, and they are supporting the men in grey suits as well. As simple as that. And how do they get across the message? As many people have noticed, sartorially. Interesting, no? Really interesting. And what was very amusing as well was that the Princess of Wales's suit was the Prince of Wales's check. Just in case people missed that little detail. And now we get on to the really meaty, substantial matter at hand. And I am going to be referring to my notes throughout, because this is our legal hot potato. And I have been in touch with various people making my sentiments known, and shall we say, reading the room. And so I will do it by answering Shane W.'s question. Lady C, what do you make of the revelations in today's papers that Harry is blaming his lawyer for having roped William and Kate into his suit against the Mail without his knowledge? That, my dear, is the least of it. That is the absolute least of it. Yes, Harry has done it, and Harry has been very wise to do it. But Harry doesn't understand, and clearly nor does Rachel Zane. Slap him once, slap him twice, slap him again. Mr. DeMille, I'm ready for my close-up. That they don't understand that the laws that would appear to have been either breached or skirted so close to that one could think that they might well have been breached. Harry can't distance himself from the consequences of being a part of a conspiracy, and it is the possibility, according to the evidence put before Mr. Justice Nicklin in that 2-day preliminary hearing prior to the case against Associated Newspapers, that has been done by 7 of them, including Harry, Sadie Frost, Elton John's husband David Furnish, Lady Lawrence, Doreen Lawrence, a Jamaican, and I have to say I'm so pleased that I'm Jamaican because it gives me access that others won't necessarily have, and I hang my head where Doreen Lawrence is concerned, and Elizabeth Hurley, who alleged that the Daily Mail hacked phones, tapped landlines, and bugged cars, all of which the Mail strenuously denies. The tragedy of this is that Doreen Lawrence owes the Mail a huge debt of gratitude, because it is the Mail that, against all odds, spearheaded the campaign that got justice for her when her son Stephen was so awfully dispatched to another planet. Let's put it that way. She has had her head turned by the status of the other participants, according to a certain Jamaican. People can't believe that Doreen Lawrence has managed to get herself roped into what is emerging as a conspiracy, a genuine conspiracy, not a sort of YouTube conspiracy, and not a Sunday Times conspiracy, and not a Sunday People conspiracy, but a genuine criminal conspiracy. That's right, a criminal conspiracy. We will get to that in a moment, because rather more serious than Harry's disclaimer is the contention that there has been an attempt to mislead the court with what was decorously called in court by the Associated Newspapers barrister a camouflage scheme to get around the statute of limitations. And I'm going to come to Mr. Justice Nicklin's response to that very serious accusation in a moment. But I'm going to make the point that I have the highest regard for Mr. Justice Nicklin's integrity and intelligence. Mr. Justice Nicklin was the judge in my case against the Daily Mirror. And Mr. Justice Nicklin gives the other side all the rope it needs to hang itself. He did it in the case that I brought against the Mirror Group, and he is doing it in this case. And I have to tell you, as those of you who watch this show regularly will know, I am very critical of the Mail and associated newspapers when they deserve criticism. And I am going to be the first, and hopefully not the only person, to point out to you, and hopefully it will be picked up by the rest of the media, what is really going on. Because this case is huge. It is monumental. The participants are very aware of how huge it is. If this group of ragtag conspirators succeed in their action against associated newspapers, they will not only damage free speech in this country, but they will damage and possibly cause the destruction of, with a knock-on effect, at least associated newspapers. But it will also cause all of the other newspapers, even if associated newspapers survives. It will cause the other newspapers to be terrified. We are speaking about the possibility of a 9-week £38 million in cost trial. That's what we're speaking about, to begin in January. I think it's very likely that Harry's crew, Harry's band of conspirators, will have their eyes open to the danger that they will find themselves in as a result of the way this case has been constructed to get around the statute of limitations. And there is no doubt that their legal team and some of them have colluded with attempts to get around the statute of limitations. So that in ordinary legal terms means that there has been a criminal conspiracy. And I'm going to read out to you a criminal conspiracy. This is a legal definition of criminal conspiracy. Involves a person making an agreement with one or more individuals known as conspiring to carry out a criminal act. To prove criminal conspiracy, the prosecution, and it's not reached this stage, and it hopefully won't, hopefully they will wise up and settle. Can you imagine? I'm calling for them to settle against the Mail. Gosh. Do pigs fly? Maybe. Even pigs with lipstick sometimes fly. To prove criminal conspiracy, the prosecution has to show that the defendant intended to be part of an agreement to commit an unlawful act. I ask at this point and interject. Is it lawful to fabricate news and therefore fabricate evidence that is going to get you around the statute of limitations? That is a question for people who are concerned with civil liberties in this country to ask. But the unlawful act does not have to be committed for a person to be found guilty of conspiracy. For example, a person can be convicted of conspiracy to murder if the murder is never carried out. Criminal conspiracies relate to the planning of a crime rather than the actual committing of that crime. Under the Criminal Law Act 1977, that agreement to carry out the crime is the criminal act of conspiracy. Any criminal conspiracy charge will carry a serious penalty. The penalty for the planning of a crime, the conspiracy, can be as severe as the penalty for actually carrying out the crime. There's a wide variety of criminal conspiracy offences, such as conspiracy to defraud, conspiring with another person to dishonestly defraud a person or organization out of something. Well, is it conspiracy to defraud to circumvent the statute of limitations so that you will get massive damages from a newspaper company, which you would not be able to get if you did not fabricate the news items, the stories, which then are the bridge over which you can cross the river of limitation? There are many serious offences where a person could be charged with conspiracy to commit that offence. These include perverting the course of justice. If you create a news story that you then are going to use as the linchpin for a complaint, have you conspired to pervert the course of justice? These are all valid questions that any good lawyer should ask, any policeman and director of public prosecutions should ask. And these are questions that have been touched upon in the evidence before Mr. Justice Nicklin in the last few days. And it is amazing to me that nobody in the public arena has actually noticed what's going on. It's like somebody's delivered an incendiary device which can blow everything apart, and everybody's acting as, well, maybe everybody's blind, or maybe everybody's dumb. I don't know what they are, but they're certainly something. Because when Associated Newspapers barrister says camouflage scheme, what he is saying is that they have laid down a scheme, that is, they have plotted, they have planned something covert to actually, and he actually says it. Let me see where he says it. Because he says that if you, I can't find where I put it, but he says if you don't intend basically to pull a fast one, why would you have a camouflage scheme? I'm sure I'll get to it, because here is what happened. There was an email that was unearthed in a group of emails between 2016 and 2019. And remember, these complaints go back to 2003. So they're well out of time, because the time bar is 6 years. Emails were unearthed in 2016 to 2019 that revealed that members of the legal team, headed up by David Sherborne, on behalf of Prince Harry et al., and that the legal team includes a very established, experienced solicitor called Mark Thompson, a convicted phone hacker called Graham Johnson, the former Liberal Democrat MP Evan Harris, and a Byline Times. I don't know if you remember Byline Times, but I'll come to Byline Times in a moment. I'll tell you right now, Byline Times is the supposed radical left-wing publication. It's a newspaper now, but it's also an internet newspaper. They are the ones who tried to destroy Dan Wootton's life. It is said that they were acting on behalf of Harry and Meghan, and they wanted to destroy Dan Wootton's life because Dan Wootton was a critic of theirs. And they tried to get Dan Wootton put in prison for years. Wouldn't it be actually poetic justice if they end up in prison for years? Because if they were knowledgeable of a criminal conspiracy, they could end up in prison for years. The offense can be up to life in prison. That's the penalty. Now, I'm not saying that they actually were knowledgeable, and I only say that for legal reasons, but they were certainly willing participants, and I'll show you in a second how. The ruse was for the legal research team to get around the 6-year rule. Now, this is evidence to the court, by the way, by planting new stories on their website, Byline Times website, claiming that the Mail was involved in hacking. Then they would pretend that the claimants had discovered that they were potential victims from these articles, fabricated articles planted by the legal teams, when in fact what they were really doing was discussing suing the Mail, but knew they would run out of time if they didn't fabricate via these articles. The damning emails involve one of the claimants, Sir Simon Hughes, the former president of the Liberal Democrats. See how high up this goes? And it showed, and I'm quoting, astonishing discussions how to cheat the legal system. Now, that's the evidence put before Mr. Justice Nicklin. Now, I am amazed that nobody else has picked up that that is a serious allegation of a criminal conspiracy. There's also Sadie Frost involved, because it was asserted that questions need to be asked about whether she misled the court, because it was revealed that the legal research team working for Harry and the rest of them had apparently discussed how to get around the strict court rules when they were threatening to sue, because under the law, privacy claims, as I said, need to be brought within 6 years, otherwise they're time barred. That limitation exists for all parties to ensure that justice is served. And notice how they set about getting around the law. Now, is that a conspiracy to pervert the course of justice or not? There is a strong legal argument for the fact that that is precisely what a conspiracy to pervert the course of justice is. There was an email headed Daily Mail Hacking, sent by Dr. Harris, who was one of the people involved, one of the lawyers, to Simon Hughes, who's a former Liberal Democrat Justice Minister, incidentally. I mean, you talk about knowing their way not only around the law, but by the look of it, knowing how to fabricate offense or to fabricate evidence which will enable them to get around the law. Does that not strike you as a conspiracy to pervert the course of justice? Because anyway, on the 11th of July 2019, Harris sent and copied to Mark Johnson, one of the lawyers, on the act of David Sherborne, Prince Harry's side. And I'm quoting, "The Mail hacking claims are being developed and will be ready to launch soon. To deter the Mail from arguing limitation, that is, you knew about this 6 years ago, Atkins Thompson, that is the law firm Atkins Thompson, which Mark Thompson is a part of, think it best for stories to be written in byline, which can be referred as the basis for claims being raised. That is straightforward fabrication of evidence. And if they think I am defaming them, please feel free to sue me. Because as far as I am concerned, that is straightforward plotting and planning to fabricate evidence to get around the law. You think I'm being unfair? Please feel free to sue me. I will defend it. I'll see you in a court of law. Well, Mr. Justice Nicklin, as I said, of whom I have a very high opinion, I have much respect for him. The way he conducted himself in my case was wonderful, and he's also very tolerant of the other side's rights, so that he gives them enough rope to hang themselves with. Because on 3 separate occasions, if I remember correctly, the Mirror Group kept on coming back to court, making allegations that they had been instructed they were not allowed to make. But he allowed them to make them. Why? To prevent them from being able to successfully appeal whatever judgment he ultimately made. So he's very cautious, but he's very sensible. And what does Mr. Justice Nicklin say of these emails? It tantalizingly suggests, that is the impression I have at the moment, that by that stage there had been amassed pieces of the jigsaw. Now, I'm not going to put words into Mr. Justice Nicklin's mouth beyond saying that jigsaws are puzzles, and pieces of a puzzle, when put together, can be a way of describing a conspiracy. Certainly a scheme or a plan or a plot. Now, this is a very serious allegation in terms of what associated newspapers have said, and Mr. Justice Nicklin seems to have understood. Because if it emerges that a complaint can, and I would imagine after all of this, associated newspapers would make the complaint, that there was untoward plot, plan, scheme, conspiracy, whatever word you wish to use, to create evidence that would allow the claimants to circumvent the statute of limitations and profit to the tune of tens of millions of pounds apiece, plus the £38 million it would cost associated newspapers if it lost the case and if the plotters succeeded in their objective. That, if I would imagine that associated newspapers, if it gets to trial and the findings go against the claimants, that they will set about making complaints against the conduct of all the legal parties involved, especially the legal advisors, David Sherborne, Mark Thompson, etc., etc. They stand, if this happens, a very great chance of losing their practice certificates. According to the senior solicitor, Mark Thompson of Atkins Thompson, he said that Sir Simon Hughes had given the court a statement of truth, saying that he found out evidence only in early 2022, 3 years after this email was sent. Another email sent in August 2017 from Dr. Harris to Miss Frost says that he would discuss with Mark Thompson hacking issues as we have gathered more evidence since we last spoke. This suggests that Sadie Frost was already discussing matters that were ultimately would have been time barred if the discussions were taking place when the emails indicate they took place. And what was David Sherborne's reaction to all of this? He swept it away with the claims that the characterization of the emails was dramatic. Well, how dramatic is dramatic? Because the fact of the matter is that he can sweep things away as if they are irrelevancies when they are clearly irrelevant to anybody who knows anything about the law. And I would say that if they have any sense whatsoever, they're going to not try to brazen this one out. And Harry can bawl and squawk all he wants and try to put as much distance between himself and this case. But if it should emerge that some of the participants are charged with conspiracy to commit murder, or even if they're not, as long as there is a valid reason to question whether there was conspiracy to commit, it's unbelievable. I don't know what you think, but I think it's unbelievable because they have definitely, according to their emails, conspired, because a conspiracy is more than one person making a plan to get around the statute of limitations. And this is going to cause a huge problem for all of them insofar as I can see. Unless, of course, they find a way of withdrawing the action. But it's pretty late in the game to withdraw the action, and if they do, they are all facing financial wipeout. And David Sherborne, well, I hope he's sensible and he instructs advises, I should say, because it's a client who instructs. It is the solicitor or barrister who advises. I think he should advise the solicitors in question because he's a barrister. So he doesn't necessarily give advice. He gives an opinion which the solicitor then passes on as advice to the clients. That's how the system works. And I would hope that he's going to advise his clients through their solicitors that maybe the time has come to settle, because who knows, one of these days I may need David Sherborne to defend me, because just in case my wonderful Casey, who has been so marvellous in representing me against the mirror, should get run over by a bus. I'd like a backup, and David Sherborne is certainly sharp enough to be a very capable backup, as Colleen Rooney can confirm. And on that note, I'll say thank you very much for listening. I hope this has been of some interest to you. If it has, please keep the questions and comments coming in so I will know what you would like us to be speaking about. And also, if you have truly found this enjoyable, would you care to like, share, subscribe, press the notification bell, and take good care. Bye-bye.